Is the PowerPoint on the screen? I assume it is. All right, I continue. So today's lecture, I'm really going to talk about four different parts. I'm going to talk a bit about the context of litigation, particularly in Australia. Then I'm going to talk about technology and pre-trial. And under that heading, I will be talking about electronic filing, case management, electronic discovery, e-discovery, and pre-trial hearings. The third part of my lecture will be on technology and the trial. That's going to be managing and presenting evidence. And we'll look at some of the digital aids for that, evidence by audio-visual link, broadcasting proceedings, and finally, we will conclude with the fourth topic, online dispute resolution. So turning to the context first. The first thing about Australia, just to put some, I know some of you will already know this, and so I apologise, but just to remind you, Australia is a federal system, and we have a national jurisdiction, we have 6 state jurisdictions and 2 territory jurisdictions. In Australia, criminal justice and civil justice is the responsibility of the states and their state courts, not the national government, not the national courts. So what it means is if you go to Melbourne, the criminal law can be different from Sydney or from Adelaide, where I am. Similarly, the way the courts work in Adelaide can be different from the way the courts work in Melbourne and in Sydney and in Canberra, so that there is a big diversity of approaches in Australia, but there are some common themes. As you all know, the common law system is at the heart of Australian law, and common law, of course, involves judge-made law as well as legislation. But what we are finding is that increasingly legislation is replacing
2020 with the Honourable Speaker, Professor
so that
David
the role
Bamford.
of judge-made law in our legal system
The Honourable
is getting
Dean
smaller,
of Faculty of
and
Law,
the role
Universitas
legislation
Diponegoro,
is
Professor
playing
Dr.
is getting
Retno
much
Saraswati,
larger.
SHM Hum, the
So,
Honourable First Vice Dean, Faculty
on.
of Law, Universitas.
So one of the big differences with the United States is that Australia does not use juries in civil trials. There are some exceptions, but the case is decided by a single judge sitting by themselves. Procedural law is based on common law principles that developed over the last 1,000 years. Now, there were some big reforms in England in the 1870s that were adopted in Australia, because at that stage, Australia was still a British colony. The colonies Australia became a federation with our states in the year 1900. But from 1870s till now, there has been a period of not much change until the 1980s. From the 1980s on, there's been a procedural revolution, and Australia became, as part of that, some European civil law procedural principles have been adopted in the year. But also, and what we're talking about today, is there's been a technological revolution in our courts. Now, and so that's really happened since the 1980s. A period of not much change So, moving on to, as I said to you, there are 4 parts. That's the first part. My second part of my lecture is about technology and the pre-trial, particularly in Australia. Now, let me begin by talking about some of the defining features of common law procedure. I assume it is. They are the reliance on oral evidence, talking about some of the defining features, the importance of cross-examination, the use of what we call discovery, a single continuous trial. They are all parts of our procedure that are particularly based on the common law principles. All these different aspects have been affected by the developments in digital technology over the last 30 years. So I'm going to go through and talk about some of these. And unfortunately, because I don't have audio, I was going to ask some questions of you to see how it compares with what's happening in Indonesia. But maybe we can do that in the end. So the first one I'll talk about is electronic filing. This is the filing of documents at the court. All right. So one of the changes that is happening in Australia, and it's been quite slow, started in about 2000 and getting faster over the last few years, is that instead of having to go to the courthouse with your piece of paper to give to the court to begin your case or to provide documents, increasingly we are now using online forms and in fact paying our court fees online. This means that the courthouse can be actually open 24/7. And so there are different ways of doing it. In some Australian courts, you go to their website, you fill in the details, and then you press create, and the court website will create the document, the form, the summons, or whatever you need. And then they say, do you want to lodge it? In the 1870s, they'll say pay the court fees in Australia, and then you commence because at that stage Australia was credit card, a British colony. The case we did not the paper is lodged, the document is lodged. Became so the whole thing is done online, and that's increasingly happening with our states. In the you might think that's quite a easy process, but 1870s. The reason why it has taken so long is to develop the technology and integrate it into the court system until the 1980s. Is quite complicated. From the 1980s so this is just a quote on the slide. Revolution. I have to confess, and it doesn't mean much to me because I don't know many of this much of the software. But basically, it says, for example, talking about today, court programs. It's a system based on a Java platform, so that's including the Spring framework and the Hibernate object-related mapping (ORM) library running on an IBM WebSphere application server. It uses Westpac's Quick Web Gateway for payments, an Oracle database, Avoca's Smart Form for electronic forms, Green ID technology for online identity verification, and Drupal's open source CMS. Now, as I say, don't ask me to explain all that, but nevertheless, it gives you an indication about how complex the different systems have to be integrated so they all work together in a smooth and effective way. So you can see, as a result, integrating and developing these systems in courts has been quite slow and quite expensive. And that's one of the reasons why even in Australia it's taken up to 20 years for some courts to get these systems working properly. So that's just to illustrate the complexity of the technology which we're now using in our courts. I want to then move on to another way in the pre-trial stage that courts are using technology, and that is with case management. Now, case management is something that has been quite a radical development in Australia over the last 30 years. And it, in fact, resembles a bit what happens in the European civil law procedure. And it is really taking a look at the role of the judge in the court. In the common law world, the judge only determined what happened at the hearing. The court was not really interested in the pre-trial process. They left that to the parties and their lawyers to organize the case for preparation for court. But what's happened since the 1980s, the courts have said, no, it's because there were so many delays, backlog, it was becoming so expensive. The court said to create efficiency and to protect the system of law, we will take responsibility for supervising the progress of cases through the litigation stages. So what happens in the pre-trial process, the parties still control the litigation, but the court controls the progress. And it does that by setting timetables, by making sure the parties and the lawyers keep to the timetable, and they keep reviewing the case all the way through to make sure it moves through the court smoothly. So that's something which didn't exist in our common law procedure until the 1980s and 1990s, and only really in the last 20 years has become widespread and total across Australian courts. Now, of course, when you have systems of paper files and paper documents, for courts to keep track of all their cases is very complicated and difficult. And so very quickly they realized that technology would help them manage the supervision of cases in the pre-trial phase. So they have databases they've been able to create. They've been able to create, instead of having to go to the courthouse with your electronic scheduling paper software, so the court is able to keep track of the cases in it. Now, in courts with small numbers of cases, maybe the paper system can still work. But when you have courts with very large numbers of cases, the only way they can effectively manage the cases in it is by use of technology. And so technology has enabled case management to work and spread through the court system. So that's the second way. Electronic filing is the first. The second is case management. The third one I want to mention is electronic discovery. Now, electronic discovery is something that the civil law tradition, the European civil law tradition, has not had, but it is actually in some countries in Europe in particular, and in South America, they are looking to explore having some discovery in their procedural law. So what is discovery? Basically, discovery is where the parties are required to disclose to the other side, the opposition, the other party, the details of the documents that the party has that are relevant to the case. In other words, if I'm on one side, I have to look at all the documents we have, and I have to tell the other side what those documents are. Now, this sounds very strange in many systems. Why should I help my opponent by giving them information? Well, it's part of the tradition of saying it helps establish the truth of the case if all information is available to the parties. So basically, discovery requires a party to examine its information and decide if that information is relevant to the case. Then, if it's relevant, the question is that information protected from being disclosed to the other side? There are some legal protections for parties. So, for example, any communication between a party and their lawyer is protected and is not required to be provided to the other side. So there's so the second set of issues is if it's relevant, is it protected information by some rule of law? If it is not protected, then that information must be disclosed to the other party. Now, these rules developed hundreds of years ago, certainly in the 1800s, 1700s, 1800s, 1900s. And of course, they were developed at a time when we only had paper, and we didn't have photocopiers, we didn't have faxes, we didn't have. So the amount of papers that existed when they developed these rules were not great. But we all know since the advent of the typewriter, the computer, the photocopier, that the amount of documents that are being created has grown enormously. Then, of course, with the digital age, we have a whole lot of electronic information that's being stored electronically. And that has made this process of discovery, particularly in big commercial cases, very, very difficult and very expensive. So, for example, in some cases, commercial law cases, large corporate cases, sometimes they say there can be millions of documents involved in a case that have to be examined and then looked at and then decisions made about the information and then disclosed to the other side. So we are talking about millions. The other thing that's happened is, in the old days, all you had to disclose were documents, but they've now given documents a bigger meaning. So documents actually includes any electronic information. So your texts, your emails, all those things are now regarded as being documents. So if you think about it, what's on your mobile phone, anything that's relevant to the case has to be provided to the other side. So the amount of information that has to be disclosed is just vast, absolutely vast. That's at the moment, but it's going to get worse. Excuse me. So, for example, we are now talking in the technology world about the Internet of Things, the IoT, Internet of Things. So these are all the devices that we have that are managing our lives for us. And it can include everything from things turning on machinery in the home, security systems, even personal information. So, for example, you might have a Fitbit that tracks your movements. Your phone might track your movements. When the system turns on the air conditioning in your house, that information gets recorded. And so that could be relevant to a case. And so, for example, there might be a question about where a person is. Were they home at that time? Well, if your air conditioner is turned on at that time, that could be evidence that someone was home at that time. So all that information now could also be included in what has to be discovered as part of the discovery process. So you can see the amount of information we're talking about is immense. Now, as a result of this, we're now using technology to try and manage this process for us. And there's a whole new industry specializing in electronic discovery. So this next slide I've got just illustrates some of the companies that have set up things. So on one hand, there's a company called relativity.com. You can look on the internet all about relativity. It's a big company that does a lot of work in this area. IBM have a program called E-Discovery Manager. And that, again, deals with the whole electronically stored information problem. Even Microsoft 365 actually now has in it a e-discovery capacity, a process for identifying and delivering electronic information that can be used as evidence in legal cases. I'm reading from their advertisement. So you can see that's just an illustration of how widespread it is. You have the old-fashioned technology giants like IBM doing it. You have specialist e-discovery companies like Relativity, and then you even have general ones like Microsoft 365 also have e-discovery built into their software now. So it just shows how much e-discovery is spreading through the system in a major way. So how does technology help with how does e-discovery work, really? Well, there's many different ways. For simple cases, sometimes it is simply scanning documents into electronic form, and then creating databases and keeping track of where documents are. So it's managing data. That's a very simple one, but still having people do all the work. But we are now also moving into more sophisticated uses of technology in e-discovery, and that is using machine learning. So the machine makes the decisions about the documents, not the lawyer. And this is sometimes called technical assisted review. Technical assisted review, TAR. And so the way it works is a lawyer will provide a sample of documents and code them according to whether they have to be protected or disclosed. And the machine will learn from that process about how to treat documents. And by doing this over and over again, the machine will actually learn and develop algorithms will be developed to enable the machine to look at documents and then make a decision about whether the document has to be disclosed to the other side or not. So as you can imagine, it's quite an expensive and difficult process. But if you are to give you an illustration of how this works in real life, there is an Australian case I can refer you to, McConnell, Dowell Constructors and Santam Limited. This is a 2016 case, McConnell, Dowell Constructors. In this case, which involved the construction of a pipeline, okay, and was a big dispute between the builders and the people who want the pipeline built. When they started the dispute, they estimated that there were 4 million documents that related to this case. And then by process, they worked through and reduced that number to 1.4 million documents. Now, those documents they worked out, that 1.4 million, would take 583 weeks to look at if a lawyer was to do it. It would take a lawyer 583 weeks, 10 years, more than 10 years, to look at all those documents. So they wanted to use machine learning, or technical assisted review, as I called it. And they used this process, and it reduced the number of documents to 208,000 documents. And they still hadn't finished the process when the case moved on. So that's just an illustration of how this machine learning can actually make a big difference. Of course, one of the consequences of all this is the courts and the judges now have to know about technology because they have to make rulings about the technology. So, for example, what happens if one party uses one electronic discovery system, maybe the IBM one, and another one uses Relativity? Maybe they are using different databases, asking different questions, and so the outcomes will be different. So the court has to control this process to make sure that both parties are operating on the same platform with the same parameters, with the same coding, so that the outcome is consistent and can be shared between the parties. So this is quite a technical growing area. Now, I don't know about Indonesian judges. Maybe they are better than Australian judges. But many Australian judges are not very good at using computers and technology. So that this is a bit of a challenge. And the courts are having to build some new skills and understandings about how this works. The last topic I want to discuss under pretrial, before I move on to trial, is pretrial hearings. Can I say, in our system, most of the court hearings that happen in courts from day to day are actually pretrial hearings about preparing the case for trial. Normally, or very often, they are not contentious. The facts are not in dispute. The issues are not really being fought hardly. It's more, maybe they're applying to the court for more time to do something. Maybe they are asking for permission to take some procedural step in the case. Sometimes it's opposed, sometimes not. Now, these procedural hearings are held before court officials as well as judges in their offices, not in a courtroom. So that it's almost like a private hearing. It is open to the public, but it takes place not in the courtroom, but in the office of the judge or the court official. Now, what's happening is increasingly those procedural hearings are not face-to-face or in-person hearings, but are being done on what we call the papers. In other words, the court gets the documents, they read the documents, and they make a decision. If they want to if they have questions about it or want to hear from the lawyers, they may do it by telephone or increasingly online now. So rather than having the lawyers have to go to the judge's office, they can stay in their office and they can communicate online with the judge about the procedural hearing that they're having. So that's been very effective and saved lawyers lots of time. So generally they do like this process quite a lot. So that really covers the headings that I wanted to talk about under pretrial: electronic filing, case management, electronic discovery, and pretrial hearings. So in the remaining time I've got, I'm going to talk next about technology in the trial, which is my third topic, and then I'm going to finish by talking about online dispute resolution. So let's turn to technology and the trial. On the slides, which I am hoping you've got, you can see that I've got some photos, and you'll see what modern courtrooms in Australia look like. These are typical courtrooms, and this could be in America, it could be in Canada, it could be in Australia. But these days, courtrooms now have lots and lots of computers in them. They have big computers on all the desks for the lawyers and for the judge, so that you can really have direct high-level use of technology. In 1997, a leading United States academic in this field said that there were 50 high-technology courts around the world. That's 23 years ago. I can tell you now, in the one building in Sydney, which is the ordinary court building, there are 20 courts set up as high-technology courts. So high-technology courts are spreading all through the Australian system in almost every jurisdiction. Well, in every jurisdiction, you will have high-technology courts operating. So, under my topics of technology and trial, I'm going to talk about how we use technology in the trial. The first one I'm going to talk about is to assist in presenting evidence. And on the slide, I've just got two illustrations there. One talking about just to show how people are using visual aids in court cases. Now, this is particularly true in North America, where they use technology to help present their evidence to the court. It can be from PowerPoint. It can be from 3D visualizations, simulations. recreations. And so here are just some examples I've taken to show you the way in which they're trying to present evidence to the court. Now, as I said, that's very big in North America, not so big in Australia, because, as I said earlier, one of the big differences in Australia from America is North America is we don't use juries in civil trials. In a civil trial, it is a judge alone, a single judge deciding the case. It can be a case for $500. It can be a case for $1 billion. Still a single judge, all right? And the judge has access to all the evidence. The judge can ask questions of the witness. And so we don't use technology in Australia because this sort of digital technology is really being used to inform the jury to persuade the jury. And as I said, we don't have juries in our civil trials in Australia in general. So yes, so this is important in North America. In Australia, not so important, not used so much, but it can be. It is very important in criminal cases where there are juries, and our courts do allow parties to present digital evidence using digital aids. So that's the first one. The next one I want to talk about, and I want to spend a bit of time talking about this one, is evidence by audio-visual link, or remote evidence it's sometimes described as. And I've got some slides here, which I hope you can see, photos of, in two cases, two courts in actual action where the witness is giving evidence by audio-visual link. The top one is from England, and is actually I think from memory, and is actually a police, it's a criminal case, and a police witness is giving evidence. The bottom one is actually from Korea, and it's actually the first time that they used audio-visual links for witnesses in Seoul. And so this is a photo of the Seoul court at work, hearing from a witness on the screen. On the right side of the slide, you'll see a photo, and this is what we call a remote witness room. One of the big issues around remote witness is that how do you ensure that the witness is giving evidence freely and without influence from others and in a safe environment? Now, we tend to, in our courts, we do have what we call remote witness rooms, which are set out to enable a person to give evidence. Now, if you look at the slide, you will see that actually it is very sterile, and the witness is just by themselves looking at a screen. It has none of the personal interaction that you get from face to face. Now, sometimes that personal interaction may not be good for the witness. So, for example, quite often in cases involving children or in cases involving sexual assault cases in criminal law, the victim likes to give evidence not in court, but from a private room. So this room might be in the same building as the courtroom and just being fed to the courtroom next door to give the witness some protection and some privacy. But in general, in the civil system, the use of often evidence is given not from a remote, from a special room in the court, but from wherever the witness is. And so there are questions about how do we make sure that that evidence is being given freely and without influence. So that's just some photos to give you some background. Now, some comments about audiovisual links. Of course, in Australia, like Indonesia, we have big distances. And so the use of audiovisual technology is really useful, particularly for those not in the big cities. Excuse me. So in Australia, we have had a long history of using audiovisual links for people in the small towns so they don't have to come to the big city to give evidence in a court case. But in terms of hearings, audio-visual links are really good for procedural hearings and for appeals. But when it comes to trials, there's some concern that audio-visual links are not good in some trial situations. There's a concern that it may actually affect the quality of the evidence given by the witness. In other words, if you're giving evidence by remote audio-visual link, you can, in some cases, miss the non-verbal communication that goes on from the body language, from the expressions. It really depends on the quality of the audio-visual link. If the person is very small in the screen, you can't really see what their face is saying. Of course, if you've got a good audio-visual link and close-up, then you can see very easily what's going on. So it does depend a bit upon the way in which the audio-visual links are created and managed. In our system, I mentioned earlier, one of the defining features of the common law process, procedural process, is a belief in the role of cross-examination. Cross-examination, of course, is when the other party's lawyers asks questions of your witness to try and show your witness is not reliable or wrong. And quite often in court cases, when it becomes down to two competing versions of events, one side says this happened, one side says this happened, and they're different. Courts have to make up their mind which version is they're going to believe. And what they do is they say, we make an assessment of the credibility of the witness. How reliable is the witness? And in our system, judges have said for many, many years that they want to see the witness give evidence in court, because it's the way the witness gives evidence tells them whether the witness is lying or not. So the courts have said really important to us to be able to see and also for the jury in criminal trials, to see the witness give evidence. But of course, what we know from science, and particularly psychology, is that how a witness looks when they give their evidence is really a poor indicator of the reliability of that evidence. So we have a mismatch. Courts say, we can look, by looking at a witness, we can tell whether they are lying or not. And science is saying, actually, you can't. A good witness can lie very well. So that this tension. And so that basically, but that has been the approach of the courts. Where there has been a question of credibility of the witness, the courts have not liked to use audiovisual links. That's been not always, but that's been a general approach by our courts. Let me just say that the research on courts, on how audiovisual links have worked in courts, hasn't been consistent, but generally the feeling is that audiovisual links are not as bad as people were worried about before we started using them. There are some disadvantages, but by careful management, we can overcome many of those. So that's one issue. But the downside is like this lecture where I don't have any audio view and I can't actually see it in my screen. My screen, unfortunately, setup has now moved, so I can't actually see the picture of what you're seeing on your screen. Anyway, my third topic on pre-trial hearings, and my last topic, is the issue of broadcasting proceedings. I don't know in Indonesia whether TV stations can go in and film what's happening in court. In Australia, it is very rare, very, very rare. It does happen. Courts have power to let people broadcast proceedings from court, but the courts have been very reluctant because they are worried it'll affect the way people in court behave, and they want to protect the privacy of people who go to court. But what is so that's TV stations coming to record. But what is happening is now some courts are actually starting to record their hearings or some of their hearings and place them on the web, on the internet. So, for example, our High Court of Australia, that's the highest court. It's like the Constitutional Court in Indonesia. Our highest court actually has on its website links to hearings. So you can go and see, watch hearings of some of their cases. That court only deals with appeals, and so they are all appellate cases. Some state courts now also provide audiovisual copies of their hearings, which you can then watch. And in fact, they tend to be around handing down of judgment or decisions, not the hearing itself, but in at least one state, they have actually live streamed some hearings. So it is slowly, you can see slowly change is happening there. One of the other things, which is one of the reasons why I think it's actually becoming more possible to get live streaming of or audiovisual recordings, is because a large number of our judicial inquiries, or what we call royal commissions, now have live streaming. So, for example, all the major, these are more administrative inquiries, not judicial, not a court case, but occasionally judges get asked to hold an inquiry into some issue. So some of you may recall that at the beginning of this year, we had very bad bushfires in Australia, very, very large fires. And so the government appointed some judges and others to hold a inquiry into those bushfires about what happened and how to prevent it happening again in the future, or how to improve our response. And all those hearings are available online. We have another Royal Commission into the way in which we treat old people in our society. And that's been going for, I think, 3 years. And they are just finishing, but all their hearings are online as well. So you can see that experience is leading to more and more use of live streaming, is likely to lead to more streaming of cases, or at least recording of cases and making them available on the internet. So that's broadcasting proceedings. My fourth topic, and I know I'm getting close to my time, is online dispute resolution. Now, this is a really big area. Traditionally, it grew out of private dispute resolution, all right? But as I say at the end in a moment, it also now exists in some courts. So basically, online dispute resolution, it grew out of in the 1980s and 1990s of a need to do with all the problems that were arising out of the growth of e-commerce, internet commerce. So, for example, eBay, PayPal. By 2016 alone, eBay had 60 million disputes per year between buyers and sellers. So they had to create a system for resolving those disputes. And the one they developed was called Modria, M-O-D-R-I-A. And that was set up to use the traditional alternative dispute resolution, ADR techniques, negotiation, mediation, arbitration. So all these things were set up to try and bring those disputes within that, and to manage that process online. So they basically had an online negotiation tool, online mediation tool, online arbitration tool. But there were humans involved. eBay had people who would actually help the parties through that process. In 2011, that Modria became a company in its own right and provided its service not just to eBay, but to anyone who wants to use it. And in fact, some courts are now using Modria as a dispute resolution process in the court. So, as I say, it's basically taking ADR, alternative dispute resolution, online. That's technically what it does. Now, I said Modria, for example, uses humans as mediators, as arbitrators, all right? what's happening now is some companies have developed software whereby there's no human involved. It actually uses machine learning to help people resolve their disputes. They develop algorithms based upon the number of a huge range of cases they deal with and what the outcome will be based upon previous experience. And so, in effect, the parties can, using this software, can try to negotiate and settle. And it's online learning, it's machine learning, algorithms, and it's been developed to help resolve disputes online. Now, I did say some courts are moving totally online, and one of the first to do this, first as far as I know, is in Canada, the Civil Dispute Tribunal. And it's now got an online process whereby people begin the case online, try and settle it online, go through mediation online as part of the court process, and then if it's not resolved, have the tribunal member, the judge, decide the case online. So a complete whole online court. Other countries are moving down this path as well. In England, United Kingdom, and also Japan has announced last year it's going to move some of its cases into an online court scenario. So you can see that's another big growing area. That's a complete holistic system where the whole process is dealt online from start of the case to finish of the case. And that's the way I think we'll see things going in the future. So to finish off, can I say the picture I've been trying to present to you is of courts that are traditionally very conservative. They are very slow to change, don't have a lot of technological experience and expertise available to them. And so things like audio-visual hearings have been slow to happen. Broadcasting proceedings has been slow to happen. But what's happened this year, I think, is a game changer. COVID-19 has really changed things for us. And I'm not sure I'll go back to the way they were before. In March this year, when COVID arrived in Australia, the courts closed. Courtrooms closed, registry closed. So how were the courts going to operate? Online, of course. And so very quickly, some courts closed down and said, we will wait till after COVID. But most courts have now realized that they moved online very quickly. And so very quickly, we suddenly had courts doing Zoom, doing Microsoft Teams, doing WebEx to try and manage the hearings. And if you go online, if you Google online hearings, court hearings, you can see some of those hearings online at the moment. So that has but what that has meant is that a lot of judges who didn't like technology, didn't like Zoom or Microsoft Teams, have had to start using it. And what I've found in some judgments this year is judges saying, actually, this works better than we thought. Our concerns about having face-to-face witnesses perhaps is no longer as important as it was. Now, I'm sure post-COVID, when the world gets when we get back on top of COVID, courts will still go back to some of their old ways. But I do think the experience of this last year, 9 months, has meant that it's much more likely that courts and judges will accept technology much more and use it much more in the future. So I think COVID is going to be a significant game changer in the take-up of technology in civil procedure. So with that, thank you very much. I apologize for the technical problems we've had, but hopefully we'll overcome them in a moment. So thank you very much.
Thank you, Professor. So participants, if you have any question, you can write down on the chat section, due to the technical matters from Professor David. So please kindly write down your question on the chat section, and then Professor David will answer it for you.
Okay, I can see the questions on the chat. Shall I start addressing some of those questions? Because I've still got no sound. So I have a question here from Zara about broadcasting court proceedings. And does broadcasting play an important role in the judgment process? Now, courts, one of the reasons why courts have been reluctant to adopt broadcasting of proceedings is not that they're so worried about the judge's role, but they are worried that the lawyers and the witnesses might behave badly, maybe they will make it into some sort of entertainment, public entertainment. And so that in that way, the outcome of the case could be affected. Now, I have to say, there are some commentators who say, if you broadcast and the lawyers and the witnesses know it's being watched by the public all over the world, they may behave much better than if they're just in a private room by themselves. And so it's not clear what the answer to that is. You can argue both ways, but I think the evidence that I've seen so far, well, in fact, the evidence of the research done on this has shown that basically broadcasting proceedings has never been a negative effect on the court process on the whole. It is, in fact, what it does, it enables people to see the courts at work. And as you say in your question, transparency is so important, open justice. And what better way of getting open justice than to have the hearings of the courts available online? So I think that's a better way. I'm less keen on media doing broadcasting. I think the court has to control the broadcasting and has to have rules about what's being broadcast. So on that basis, I agree that it's very important. Now, the second part of your question was about online dispute resolution. Is it effective? This is a very good question. So basically, the parties have to, in a sense, agree to the process of ODR. As we all know, with private dispute resolution, if you don't do it through the court system, how do you enforce it if one party does not do what they said they would do in the settlement? And if that's across countries and different legal systems, then it becomes very complicated. The other problem we have is things like eBay and PayPal and international commerce, e-commerce like that, is dealing with normally consumer transactions. That is small value transactions, many millions of transactions, but the amount involved in dispute is not very big. If I buy a pair of shoes online, it's not going to cost me a lot of money. All right. So that if there's a dispute, it's not worth going to court. The court is too expensive. So you've got to find a mechanism whereby these low value, high volume cases have been dealt with. And the evidence on online dispute resolution from eBay and PayPal, for example, does show they've been pretty effective mechanisms. So it's worked there. Will it work with lawyers in the legal system? Certainly the Canadian experience, if you look at some of the things that are happening with the Civil Dispute Tribunal in British Columbia, Canada, in Vancouver, basically they claim to have had very good results from those who've been involved in the process online. So that that's that question from Zara. Let me ask the question. Next question I've got is from Scholastica. Yes. Are there problems within? What are the downsides? What are the bad things about technology? Well, firstly, it's expensive, and you have to have people who are able to have access to it. And one of the arguments is that not everybody has access to a computer or internet to make it work. So in Australia, one of the things we've done about this is, for example, if you go to a town, most towns in the rural areas will have a public building, a library, and quite often they will have computer facilities set up there so people can come and use the computer. But of course, that's in a public space. It's not private. I do think there are some real problems about that, about technology in that way. So that's a significant disadvantage. The other one, as I said, is that it's actually very expensive, and courts have been very slow to develop very complicated technology. I read to you the description of the software needed to make the system work, and that can be really complex. And the other aspect about it too is security. The courts are very anxious about the security of the data. And there are all sorts of questions. In some courts, they refuse to use any cloud servers. They want everything within their control because they want to make sure that the data is protected. So that's another concern. The third concern about technology is privacy. In open justice, in our system, anybody can go to watch the court in court. There is no barrier. But it does mean that only those who want to go and look at the court hearing go. But if you have it online, then people's privacy, everybody in the world can see what's happening. And you might have very private business that, relationships or all sorts of other problems that really you don't want the rest of the world to know. And the question then is, if you know it's going to be broadcast, maybe you won't go to court. You say, I don't want the world to know about the problem I'm having with my family business or the fight I'm having with my neighbour or whatever it is. So the issue of privacy is also very much an issue within the within the use of technology in courts. I hope I've answered your question, Scholastica. I'll go to Rivet. Well, Rivet, that's a question I'm not sure I can answer. This is the question about Instagram and Facebook recording our private conversations. I'm sure one of the problems we have with social media is that, of course, when you sign up, you agree to all the terms and conditions. And I think we have 65 participants on this lecture at the moment, 64 now. And I bet you not one of the 64 people on this Zoom lecture has actually read all the terms and conditions that Zoom applies. I know I haven't, and I doubt anyone else has. But when you sign up for these social media things, you give away a lot of your privacy. So it depends on what you've agreed to in the agreement when you sign the terms and conditions, and you say, I agree. What you're agreeing to. So I'm afraid I can't really add any more to that one, Rivet. That really is a question of what you've agreed to and whether there's been a breach of privacy. All right. How are we going? Shall I keep going? Next question I have is from Akbar. Regarding technology matters, yes. This is going back to the question I answered earlier about the problems with technology. Not everybody has access to it. And while in Australia we have done much to try and deal with this, it does remain the case there are parts of Australia where they don't have access to good technology. And I know that's also true for Indonesia as well. So it is a problem. But, you know, we had a similar problem in a different area with COVID earlier. In Australia, we closed our schools and they said all our children will now study online. But of course, in Australia, there are many families who do not have online access. They don't have computer in their home. They don't have internet access. It's expensive. And so the government had to find ways of providing computers or laptops to children in school so they could do the online classes. So yes, so the question about technology and how access to it is a very important one. So the second question about how justice can comply with technology. Well, that's the big question. And I think it's about making sure the court controls the technologies. That's what is important in this process. But of course, at the same time, the courts need to have the expertise and the people who can actually help it develop and adopt the technologies and change them because it's all changing so quickly. That's going to be the challenge for courts. Courts are very slow. They are part of government. And so they're often some years behind where the technology has got to. So that's a really important one. I mean, technology is just a tool, all right? It can be good and it can be bad. With the right controls, I think technology can make a very positive contribution to justice in our system. All right. I think that's all the questions I've got. Is that right?
Okay. Is there any question for the participant? If there is more question, please write down on the chat section.
I can't see any questions now. Good.
Okay, so
all right, thank you very much. All right, can I say thank you very much for being part of this lecture. I'm sorry that we can't communicate by audio because I would like to know much more about what's happening in Indonesia. This is a two-way street, and I know there are lots of developments in Indonesia which would be important, and I'd like to hear about. But I think what in concluding, I want to again use this lecture as an illustration of how technology can actually enable us to achieve things. And this time when COVID stops in Australia, the borders are closed. The government has said Australians cannot leave the country without permission. And it's hard to get permission. So that there's no way I could come to Indonesia at the moment. But nevertheless, through use of technology, we are able to continue to communicate, learn from each other, and we can keep building our relationships. And can I say, as I said at the start of the lecture, I really admire what UNDIP is trying to do in its programs, and I really am very keen to support the work. And I know that the graduates who are coming out of UNDIP will be really good graduates and will have a lot to offer both to Indonesia, but also, I think, more broadly, as Indonesia becomes more important in the world, as Indonesia is going to be very important. I think it's a really good opportunity for us to keep building and using technology to make both the law a better place and the world a better place. So, terima kasih. Okay, one last question. All right. Jurisdictional challenge. All right. Well, no, in a sense, I'm talking about within Australia here. And within Australia, we have, as I said, we have 6 state jurisdictions, 2 territory jurisdictions, 1 national jurisdiction. But what the courts have done is they have reached agreements about how they will operate. And back in the 1990s, for example, in the area of audiovisual links, they have all the states and territories got together and they agreed on some legislation that would protect and facilitate, make easier use of audiovisual links in courts. And so all the court rules that apply, if you are doing a witness from Sydney to Melbourne, this legislation controls that and protects it. So there's no chance of trying to argue jurisdictional challenges or where the location of the witness is. All the rules about giving evidence are covered in that. So by use of those sort of agreements, by getting all the jurisdictions to agree, we have prevented the rise of these sort of challenges happening in our court system. No, it's a good question. It's a good question. Internationally, different issue. That's a much more complex one, and I'm sure will become an increasing issue in the future. So thank you.
Okay, thank you, Professor David, for the great lecture for this afternoon. Thank you for all of the participants. I would also say thank you for the Dean of Faculty of Law, Universitas Diponegoro, first Vice Dean and also second Vice Dean who already support this agenda. Thank you, and I will end the session here. Terima kasih. Assalamualaikum warahmatullahi wabarakatuh. Thank you, Professor. Thank you.